Hello everyone. So today I will be talking about Trademarks Act of 1999. So before moving towards the actual Trademark Act, it is very necessary to understand basically what a trademark is. So a trademark means any distinctive mark or a design which consists of symbol, word, sound, color, slogan, or any combination of above mentioned things. So the major purpose of the trademark or such a distinctive symbol or mark is that the common people like us, they can easily distinguish between the products of two companies and identify that which one is a genuine one and which one is not. So some of the examples of Trademark Act will include the slogan of Nokia, like connecting people, then the symbol of Mozilla Firefox browser, then the symbol for Micromax, the color of Burger King, the logo of major companies like Apple, Samsung, etc. So, what is the importance of a trademark? Why is it necessary? So, first and foremost, it serves as a interactive communication tool, and it is a valuable asset for any company, and it helps the consumers to identify the company based on its appearance only. And yes, filing for the trademark is not compulsory. It depends on the company or organization whether to go for trademark or not. So what happens if you register yourself under a trademark? So some of the advantages will include that it protects the commercial goodwill of the trader or a company. Then it helps to find out that what particular good is of what origin, basically. And it prevents other from using your symbol or similar type of mark in their products and then selling them. And it also helps in protection of the infringement claims, where certain companies will copy the logos or anything from other companies. So if you want to register yourself, what are the requirements? So first and foremost, it should be distinctive, it should be very unique, it should not be similar to any other company which is existing in the market. So it should not be containing any of the symbols or word which are prohibited or which are not approved by the law. And it should not contain any scandalous matter or any misleading information, and it also should not hurt any religious sentiments of the people, or it should not hurt any particular class or sect of consumers in the market. And also it should also not create more confusion, because actually we are filing the trademark to reduce the confusion. So it should not at least increase the confusion which is already prevailing in the market. So now talking about the procedure about how one can register for a trademark. So under the section 21 to 26, so application of a trademark can be made in any of the offices which is headed by Ministry of Commerce and Industry. For India, the head office of Ministry of Commerce and Industry is located in Mumbai, and it is again divided into further branch offices, and it regulates the Trademark Act of 1999. So depending on the jurisdiction, primarily based upon the location of the business, the company or entrepreneur can file for the trademark. So the application has to be applied to form of Trademark Act. Further, it should be noted that it should be submitted in 3 copies along with the prescribed registration fees. And form number TM55 for inquiry is necessary for distinctiveness of the inquiry, and form number TM5 for inquiring whether any identical or deceptive mark is pending for registration. And both above forms are applied with the prescribed fee. And upon receiving your application, the registrar of the office which manages this trademark will issue the application number, which shall be used as the trademark registration number for all the future references, and the registrar will then review your application. Then your trademark will be going through a examination process, and see whether there is any infringement, or whether there is any confusion with another logos. And if there is no objection in the application, then it is published in the trademark journal for third party objections, which should be raised within the period of 3 months. And after that, if further there are no objections from the third parties, then the application number will become the registration number for the trademark. And further, it is to be noted that trademarks have to be renewed once you have applied it, once in every 10 years. Let us have one case study of Pune District Court and Bombay High Court. The judgment was on the Covishield, and the date of judgment was 20 April 2021. So here are some of the facts of the case. So the applicant was Cutis Biotech, and the respondent was Serum Institute of India Private Limited. So Cutis Institute on 29th April 2020 filed an application for the trademarking of their vaccine Covishield. So on 6th June 2020, as I applied for the Serum Institute of India applied for registration of trademark Covishield under the different application number, and both the appellant and the respondent have applied for registering Covishield trademark, but their applications were pending. So what was the decision of the district court? So Cutis Biotech had filed an application for registration of trademark Covishield, which is a veterinary, Ayurvedic, allopathic, medicinal, pharmaceutical preparation and dietary food supplement for humans and animals. So whereas Serum Institute of India applied for registration of trademark Covishield for COVID-19 vaccine. So Cutis Biotech contended to be the prior user, or one which was using prior to the Serum Institute, and thus the same cannot be used again by Serum Institute of India. So on the 4th January 2021, Cutis Biotech filed the commercial suit before a district court, commercial court in Pune, for temporary injunction against the Serum Institute of India. So the district court noted that the products of both the companies were used for different purposes. Their purpose of use were different. That is, for Cutis Biotech, it was just another veterinary drug or some certain food supplement, whereas that filed by the respondent, that is the Serum Institute of India, they were using for the purpose of curing the disease of COVID-19 as a vaccine. So the district court noted that the products of both the companies were used for different purpose, and there was no evidence or any confusion in the mind of the consumers. So therefore it rejected the interim application on 30th January, and thus Cutis Biotech further approached the High Court. So after the Cutis Biotech went on to the High Court, the High Court observed that both the parties, that is Cutis Biotech as well as Serum Institute of India, they did not, any of the company did not possess trademark. So not only is there adequate evidence to show that prior adoption and user, but Serum Institute of India has also continued its use without a break. So Serum Institute of India has already produced 60 million doses of Covishield vaccine per month, and also it was supplying more than 48 million doses to the Indian government. So Serum Institute of India has obtained various permissions and licenses for the manufacturing of that Covishield vaccine. And dismissing the appeal of Cutis Biotech, High Court further stated that with these facts, the balance of the convenience is not in the form of Cutis Biotech. in the favor of Cutis Biotech. Grant of injunction against Serum Institute of India would have a serious impact on the business as well as also on the uh, uh, regulation of the Covishield vaccine, which was already uh, uh, going under for the fighting the pandemic of COVID-19. So what was the conclusion? What conclusions can we get from the above case study? That from the above contentions, it is concluded that trademark shall be granted for COVID vaccines by the registry on applications made to it, provided such trademark is not refused registration on absolute or relative grounds, and we need to further wait for confirmation on the grant of trademark to the Covishield vaccine. Also, we can note that in this case the court relied on the principle of passing off, which protects the unregistered trademark if the affected party can show that there is a misinterpretation of the trademark which will result in the loss of business or goodwill of the affected party. Further, it relied on the doctrine of the balance of convenience and refused to grant an interim injunction in favor of Cutis Biotech, not restricting the defending company from using the trademark of Covishield. So, even after the Trademark Act of 1999, such issues still prevail, and in similar cases have also happened that the principle of passing by was called into action to provide the trademark to any one company. Thank you.